Another area we practice here is what is called premises liability. That means that you are hurt on somebody else's property. The classic case that we all hear about and we get many calls on is a slip and fall or a trip and fall case. These are probably some of the hardest cases we do here. Florida law is not favorable to the injured person who's hurt on somebody else's property because it requires that we prove that the defendant, the owner of the property, have notice of the dangerous condition, have had an opportunity to correct it, or that they actually caused the dangerous condition. So, for example, if you're in the grocery store and you slip and fall on shampoo that's on the floor, you don't have a claim against the grocery store unless you can prove how it got there and how long it was there. Typically, people don't know that. All they know is they were looking at the shelf, they slipped, they found themselves on the ground, and now they have a broken leg or a herniated disc in their back. And so it's very, very difficult. If you ever do fall and you don't know exactly what you fell on, make sure that you look down and get some idea of perhaps how long it was there. Other areas of premises liability involve dog bites. If you're on somebody's property and their dog bites you, that's strict liability. If they have homeowners insurance, that will compensate you for that. I would just encourage you that if something like that's happened to you, to try to get as much evidence as you can of exactly what happened to you, and in your own mind, just using your common sense, how the landowner could have avoided your injury. Give us a call. We'll talk to you about that. We can hire our own investigators, or I many times have gone out to the scene myself, studied it, and found some theories of liability that allowed us to get a substantial recovery for our clients.